Good morning or good afternoon all. This ex parte urgent application hearing is in the matter of CFI 005-2021 and is being held by way of video conferencing before His Excellency Justice Lord Angus Glennie, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The applicant is represented by Curtis Mallet Prevost, Colt and Mosul, LLP, and lead counsel is Mrs. Serena Montalbano. Thank you, Your Honour.
Yes, Ms. Montalbano.
Good afternoon, my lord. My name is Serena Bosch Montalbano. Good afternoon. I'm with Curtis Mallet Prevost, the counsel for Ms. Donna Benton, the applicant in this application and was the defendant in the underlying proceeding.
Yes.
Together with me are my colleagues who's online also, Mr. Jeremy Miosevich, also a partner at Curtis, who has submitted a witness statement in support of this application, and he's part of the legal team representing the applicant, and Mr. Mikhail Chiking, also with Curtis, who is not online. He's in the room with me, if that's okay with you, my lord.
Yeah, that's fine.
Thank you. May I proceed?
Yes, of course. Can I tell you, I've read the draft order and the witness statement and some of the documents in the exhibit to the witness statement. So you can take it the background fairly quickly. What I'm interested in is knowing what exactly is the position in relation to the sale of this property.
Yes, my honor. I'm going to give just a very short introduction and not take you through the, as you said, the background, etc. So Miss Benton, as my lord is aware, is the judgment creditor in this proceeding. Yes. Pursuant to the judgment of your lordship of September 2023, and I will refer to it today as the judgment, which ordered the claimants in the underlying case to pay at the amount of $2.6 million to Ms. Benton plus interest. This application arises out of the applicant's attempted enforcement of the judgment. Despite more than a year and a half has passed from your lordship judgment and 8 months from the renewed permission to appeal dismissal order, the judgment still remains unpaid. And as my lord will hear today and has read in our papers, one of the judgment debtors we submit took active steps aimed at frustrating enforcement of the judgment. So in this application, Ms. Benton, this is a without notice application, and Ms. Benton seeks an interim injunction that an order that Mr. LAL, the first respondent, Miss LAL, who's Mr. LAL's wife, we understand, and Mr. Kasim, and Miss LAL and Mr. Kasim were not parties to the underlying case. They are now here for third party respondents, are restrained from selling, transferring, pledging, or encumbering the property, the villa located in Jumeirah Golf Estate. And the applicant also seeks an order that Mr. LAL must disclose his assets in the United Arab Emirates and worldwide, must disclose the consideration he received for the sale of his 50% share of the property to Mr. Kasim, and provide and that the third party respondents must provide the title deed showing ownership of the property now owned 50% by Miss LAL and 50% by Mr. Kasim. This injunction we submit, my lord, is necessary in order to preserve the status quo and avoid further harm to the applicant. The applicant next steps in pursuing enforcement, we submit, my lord, will be guided by the outcome of this application and any disclosure that Mr. LAL will provide regarding his assets in the UAE and worldwide. And depending on the information, if my lord will grant the order, and depending on the information that Mr. LAL will disclose as part of this injunction, the applicant may contend, and of course this is not an application before your lordship today, that the property is held on constructive trust, either wholly or 50% for her benefit, or may file other application and pursue other routes in aid of enforcement. We thought that this was under the circumstances the most appropriate course of action in circumstances where the applicant is out of pocket, if you will, my lord, for more than a year and a half, and is spending and continues to spend substantial amounts in legal fees to enforce the judgment.
Can you tell me, though, I understand that background. Can you tell me about the property itself?
Yes.
Before and until a year ago, say, it was owned jointly by Mr. LAL and by, sorry?
And the wife.
So it was jointly owned by Mr. LAL and his wife?
Correct, yes, my lord.
Right. So what has happened then since?
Yes, it happened that, as my lord may recall, there were two witness statements submitted by Mr. LAL in the underlying proceeding, LAL 3 and LAL 4. And in those witness statements, Mr. LAL, in fact, disclosed that he owned this villa, the property, jointly with his wife, and he also owned another property, a flat in Dubai, a smaller apartment in Town Square. After that, in an effort to enforce the judgment through the applicant's local council, we have been aware that these two properties have been sold. The flat has been sold on the 15th of January 2024. And Mr. LAL has also transferred his 50% share in the villa to Mr. Kasim. We know this information from two reports of the Dubai Land Department, which my lord will find in the bundle if you want me to refer you to the specific.
No, don't worry.
But,
sorry, when did Mr. LAL transfer his 50% share to Mr. Kasim?
He transferred his 50% share in September, on the 23rd of September 2024, right, which was after he submitted the two witness statements, after, of course, the judgment of your lordship, and after the dismissal of the renewed permission to appeal.
Yeah. But the transfer has been done from Mr. LAL to Mr. Kasim.
That's correct, my lord, yes.
So what are you hoping to achieve now? If Mr. LAL, if that was a genuine transfer and Mr. LAL doesn't have any interest in the property anymore, what are you trying to achieve?
We're trying to preserve the status quo at this stage, hoping to get additional information. For example, what we're also requesting as part of the order is the title deed and the amount for which Mr. LAL transferred his 50%, because there are concerns that this was not really a third-party bona fide sale, and Mr. Kasim, as Mr. Milosevic has explained in his witness statement, appears, we don't have evidence for that, my lord, but appears to have been a business acquaintance of Mr. LAL. In addition, it's a little strange under the circumstances, my lord, in circumstances where Mr. Lal knew that Miss Benton was trying to enforce on the judgment, and he knew that the permission to appeal was dismissed, to transfer 50% to a third-party purchaser in a property where his wife owns the remaining 50%.
So is it your case that this is not a genuine transfer, or may not be a genuine transfer to Mr. Kazim?
Yes, it may not be. That's our position right now, and we are hoping to get additional information from the disclosure.
Right. But if it is a genuine transfer, then that's the end of it. You can't do anything about it.
About the 50%, probably, my lord. But depending on the information, we are considering also an application for constructive trust on the entirety of the property.
Yes, I see. Yeah.
Yes.
Yes, I see. Okay, so I can understand you wanting information about the transfer of the property. And therefore you want an order against Mr. Lau from selling if he hasn't, or if it's not a genuine sale, you want an order stopping him selling it.
Stopping an additional sale to a third party who presumably could be a bona fide third party purchaser. So we would like to maintain the status quo so that Ms. Lal, Mr. Kazim and Mr. Lal cannot do anything with respect to this property.
Yes, I see. All right. I understand that. Do you want to look at the order then? Yeah. The draft you sent me. I'm looking at the one with the track changes on it.
Yes.
In principle, I'm prepared to grant you an order along the lines you seek, but paragraph 1 proceeds upon the basis that there may or may not be a genuine sale. But if there isn't a genuine sale, then you're seeking to restrain both Mr. Lal and the third-party respondents from dealing with the property. Is that right?
Yes, that's correct, my lord. And also the way it was drafted this way, including Mr. Lal, was because Mr. Lal, as far as we're aware, is the husband of Miss Lal. The concern was that he could exert any control or pressure on Miss Lal or the sale of the remaining 50% of the wife.
Yeah. Okay. Well, paragraph 1, I'm happy with, except the in the last line, it should be in any way disposing, dealing with, or diminishing, just as a matter of grammar.
Thank you. Yes.
Okay. Yeah. Lena, will you make a note of these points as we go through it? And then paragraph 2, why do you what basis do you seek a worldwide order?
Because my lord, we understand, and again, we don't have, I believe, a specific evidence as to all the assets, but we understand that Mr. Lal has left the UAE and doesn't own any other properties in the UAE. So.
But you can't identify any properties he owns outside the UAE.
We don't at this stage. In one of his witness statements, he referred to a pension fund, I believe, in Malta. But that was in the same witness statement where he gave assurances that he owned the 2 properties that he has later on dissipated. So we don't have any certainty as to the assets position in the UAE or worldwide.
Yes, I see. is there any precedent for granting a worldwide disclosure order without any evidence of assets worldwide?
I'm not aware of any, my lord.
I can. It seems if you do it in a case where there's no evidence of worldwide assets, then you do it in every case. Whereas this is meant to be a carry on.
No, sorry, if I may, Your Honor. In fact, for this reason, we are not seeking a freezing order right now. We are hoping to get information from Mr. LAL and then come back to your lordship again if we are able to have a detailed information about assets in the UAE. Of course, that would be preferable, or worldwide. Otherwise, we would have asked your lordship for a freezing order now.
Yes, but is it? You have to help me. Is there any authority showing that you can get a worldwide disclosure order without seeking any worldwide attachment of assets?
I'm not able to answer this question. I'm sorry.
Okay. At the moment, I'm inclined to restrict paragraph 2 to assets within the UAE, because I can't see any basis for believing that there are assets outside the UAE which ought to be covered by the order. So, unless you want to say any more about that, I would delete the words "and worldwide" from paragraph 2.
Yes, my lord. If I may, well, our position was that the reason why we didn't seek for a freezing injunction, I'm sorry to repeat myself here, was that because we didn't have this information. Otherwise, Miss Benton would be in a position where she would be limited in a certain sense if Mr. LAL disclosed 2 years ago that he had certain assets. He has then dissipated his assets. We knew that there was the pension fund in Malta 2 years ago. We don't know what's the position right now. If Mr. LAL is not ordered to disclose the assets worldwide, the remedies of Ms. Benton will be further limited.
Yeah. All right. I suppose he can always come back and argue about that. So, all right. You persuaded me that I should make it worldwide, and he can come back and argue about that if he doesn't want to do that. So I'll grant paragraph 2 as it is.
Thank you, my lord.
Paragraph 3 is fine, I think. Paragraph 4. The point of having the title deeds is what?
Well, we don't have the title deed. The only title deed we have as part of the documents we received, well, that was previously disclosed by Mr. LAL himself, but also as part of the package that we received from the Dubai Land Department. It's only the original title deed that shows Mr. LAL and Miss LAL to be the owner. We don't have the title deed, and we were hoping that in the title deed it also maybe shows the amount of the sale of the 50% share.
Would that be normal for the price to be shown in the title deeds?
I believe that the title deed, the previous title deed shows the
The price.
the purchase price.
All right. I can see, again, they can challenge it if they want to. I can't see any reason not to grant that at the moment. So I'll grant that.
Thank
And
you.
then paragraph 5. Sorry.
No, sorry.
On.
I may, it's on page 45 of the hearing bundle. There is the previous title deed of May 2021, which.
Give me a second. Page 45.
45, yes. Of the hearing bundle.
Yeah. It's in Arabic.
Page 45, my lord, is.
My page 45 is in Arabic.
Of the hearing bundle?
Yeah.
Tab 3? It's
page 48 is a title deed in English.
But the title deed that has part in Arabic, part in English, on the left shows the amount purchased from Fred Dunn in 2018 for the amount of
4,200,000 dirhams. Yeah.
That was the original one that showed both Mr. Lal and Mrs. Lal as owner 50-50.
Yeah. All right. I can see that would be useful, or might be useful. So I'll grant paragraph 4, and paragraph 5 follows from that. You're only asking for an affidavit from Mr. Lal, not from the third-party respondents.
Correct, my lord. That was just the typo because it's actually Mr. Lal who we're requesting to disclose the information.
Yeah. Very well. All right. Well, I'm prepared to grant that. Is it? Would you normally have a return date?
Yes. We are in the court's hand, really. We were thinking about 10 days for the return date.
Yes. Give me a second, can you?
Sure.
What's today's date? 6th. I'm not available 10 days from now, but Lena.
Yes, Your Honor.
What is the normal period allowed for a return date in a case like this? Is 10 days too long or too short?
We usually typically have it between 7 to 14 days.
Right. So if we fixed it for the 20th, that would be 14 days from today. Would that be all right?
From the court's perspective, yes.
How does 20th suit you, Ms. Mortabana?
It's perfect for us. Thank you.
Right, very well. We'll put a paragraph in the order providing for a return date of, this is paragraph 9, return date of the 20th May. With an estimated duration of, what, 2 hours? Lena, do we normally fix an estimated duration when you fix a return date?
Yes, we do, Your Honour.
Right, I'll fix it for 2 hours, and if it needs longer, it needs longer. So 20th May at 9 a.m. UK time, which is 12 UAE time.
Thank you.
And then I don't think there's anything else in the order. Is there anything else you ought to bring to my attention, Ms. Montalbano?
Yes, my lord, if I may. It regards to service of the order
Yes.
of the application. We understand that Mr. Lal and Mr. Kasim may be both of them outside of the jurisdiction, and I don't have evidence right now. But if my lord can authorize us to serve by alternative means under Article 931 of the IFC Courts rule, we would propose to serve Mr. Kasim at the villa where he owned the 50%, and Mr. Lal by email or on his legal representatives if they accept service.
What rule is it? What paragraph of the rules?
9.31.
Right, so you want to serve Mr. Lal by email?
By email or on his legal representatives if they accept service. We don't know if they're still instructed.
Right. We could require both, I suppose, both by email and on his legal representatives.
Thank you, if possible, yes.
What about Mr.
We would like to serve Mr. Kasim by courier at the villa for which he owns the 50%.
You don't have an email for him?
I don't.
Okay. Service on Mr. Kazim at the villa, which is, the address is what? Villa 22, Sundials, Jumeirah Golf Estates, Dubai.
Yes.
Is that right?
Yes.
And what about Mrs. Lal?
Mrs. Lal, we propose to serve her personally at the villa.
She's in the UAE, is she?
This is what we believe.
Yeah, but you can always come back and seek an order if there's a problem.
We will, thank you, my
Okay,
lord.
so I'll allow service under Rule 931, service in those alternative forms. Anything else you want to tell me?
One final thing.
Yes.
Mr. Milosevic has seen that there are 2 small mistakes in his witness statement that he would like to correct.
Yep.
Jeremy?
Certainly. Your Honour, it was just at paragraph 14 and 33, just to confirm that the dissipation of assets was after the judgment. I think.
Yes, I see.
Yeah. So I can submit, and I think it was prior to the issuance of the dismissal order, was the initial was actually after the judgment. So with your leave, Your Honour, I'll submit an amended witness statement that just corrects 14 and 33 to refer to after the judgment.
Yes, please. Will you do that? And if you can file it with the court, just a short corrective statement rather than a whole new one.
Perfect. All right. Thank you, Your Honour.
Thank you.
Very well. Ms. Montalbano, can I ask you to liaise with the court officer to work out the precise terms of the order and terms of which we've discussed today? And if there's any query, Lena, if you can come back to me.
Yes, Your Honor. Thank you.
Thank you.
Thank you very much.
Thank you very much.
Very well.